lady, I have just been through all of those statements and tweets which I submitted to your ladyship. Were hurt.
The machine is 5 minutes. The machine is rebooting. Can we adjourn for 5 minutes?
Certainly.
Thank you. All rise in court.
I was saying the statements and the tweets that I've read to your ladyship, objectively speaking, were hurtful, harmful, incited harm, promoted hatred against particular journalists. But it's also harassment. And we do deal with harassment later, but I don't want to be thought of having missed speaking about harassment. And the reason I bring it up now, my lady, is because of the next section in our heads of argument. Hate speech, which is dealt with in section 10 of the Act, says that the words must be based on one or more of the prohibited grounds. Section 11 of the Act, which talks about prohibition of harassment, says no person may subject any person to harassment. But the definition of harassment, which is in section 1 of the Act, says harassment means unwanted conduct which is persistent or serious and demeans, humiliates, or creates a hostile or intimidating environment. All of which I've already argued is precisely what we say the statements were intended to do, or is calculated to induce submission by actual or threatened adverse consequences. Again, I've made submissions about that, and which is related to, the first is A, sex, gender, or sexual orientation, or B, a person's membership or presumed membership of a group identified by one or more of the prohibited grounds, or a characteristic associated with such group. So your ladyship will see that common both to hate speech and harassment is the concept of the prohibited grounds. It appears in both. Now, the definition of prohibited grounds, which is also in section 1 of the Act, has two parts to it. Part A specifies certain specific grounds, and Part B opens the list to other grounds that are not specified, but which may yet be held to be part of the prohibited grounds. Part A includes race, gender, sex, pregnancy, marital status, economic or social origin, color, sexual orientation, age, disability, religion, conscience, belief, culture, language, birth, and HIV/AIDS status. So it's either A or B B is any other ground where discrimination based on that other ground, 1, causes or perpetuates systemic disadvantage, 2, undermines human dignity, or 3, adversely affects the equal enjoyment of a person's rights and freedoms in a serious manner that is comparable to discrimination on a ground in paragraph A. Our submission again is that in part B, 1, 2, and 3 must be read. I think the word is disjunctively. I'm not sure if that's correct. But in plain terms, what I'm saying is that after 1 there should be an or, after 2 an or, 3 an or. So it's 1 or 2 or 3. So what is clear, my lady, in our submission is that the grounds in part A of the definition do not constitute a closed list, specifically because of what is contained in B. The harassment and the hate speech that is directed against the journalists, I submit to your ladyship it's common cause that that speech and those tweets are directed at those journalists, and in some instances journalists generally, because of the particular work they do as journalists. Put differently, because of the particular beliefs or opinions that they articulate as journalists. So our submission, which we make in paragraph 23 of our heads, is that we're not saying that journalists should constitute a prohibited ground. That would be too narrow. What we're saying is that occupation should constitute a prohibited ground by virtue of part B of the definition. Because we say that discrimination based on occupation certainly meets the test postulated in B1, 2, and 3. And one can think of, if one takes journalists out of the picture, if one brings another occupation, for example, the occupation of sex workers, one can see why, in our submission, that if one were looking to, if there was discrimination against sex workers, I'll give an example. Perhaps someone who was previously a sex worker now applies to be a teacher and discloses his or her past occupation. It's conceivable that there could be discrimination against that person based on their previous occupation. Or things could be said about someone. Or a person could be harassed as a result of their particular occupation. It doesn't have to be limited to journalists. Now, B1, part B1 says it must cause or perpetuate systemic disadvantage. B2 says, or it can undermine human dignity. And there's a lot of talk in the papers from the various complainants about how their dignity has been undermined. And even if the test is objective, milady, some of the things, most of the things that are said about these journalists would certainly undermine their human dignity. The third one says there's got to be the manner in which the equal enjoyment of a person's rights and freedoms is affected must be comparable to discrimination on a ground in paragraph A. And So in other words, there's got to be some comparison done. And we submit that what characterizes all of the grounds in Part A of the definition is that they all contain within them an element of vulnerability. Each and every one of them. It doesn't mean that everyone in that group necessarily is vulnerable to discrimination. But there are parts of the group that historically or currently are vulnerable to discrimination. So, for example, if one takes sexual orientation as an example, immediately one looks to if a person is discriminated against because that person is gay or bisexual or lesbian, one can see how the Equality Act would protect such a person if there's been hate speech directed against them, harassment directed against them, discrimination directed against them. But it doesn't mean that the category of sexual orientation won't be open to a person who is discriminated against or harassed or where hate speech is directed at that person who is not gay or lesbian or bisexual but happens to be straight and is abused by virtue of that fact. Now, straight people historically haven't been discriminated against. Hence, we make the argument that within each of these classes, each of these grounds, there is an element of vulnerability. It's not that the whole class is necessarily vulnerable, but the protections, my lady, the protections apply across the ground, across the class. So the same can be said, we submit, about occupation. And it's strange that occupation is not, it should have been a listed ground, but it's not a listed ground. And we submit that it can come in under Part B of the definition.
What is it about the legal issue raised by the respondent? Do you agree that Section 10 of the Equality Act does not protect journalists from the effect of hate speech?
No.
Because that's the legal.
No, that is their submission. So, my lady, their submission is, well, they say journalists are not protected.
From the effect of hate.
Yes, from the effect or do not fall within the reach of Section 10. There's an argument that I've just glanced at, and I haven't, because it's in our learned friends' heads of argument for the first time, but they talk about these grounds are characterized by immutability, and it's only if a ground is immutable that it can be included under Part B of the definition. Now, being a journalist, they say, is not immutable, because you can be a journalist or not be a journalist. It's not something that is innate, although some journalists might disagree with that. Our submission is at least twofold. Number one, the case that our learned friends rely upon for this proposition of immutability didn't actually deal with this issue, and was certainly not dealing with the definition of prohibited grounds under the Equality Act. But even within Part A of the definition, it can't be that immutability is the test, because even if one looks at Part A of the definition, there are some grounds there that are not immutable. So, for example, well, this might be a debatable point, but I'm comfortable to make the submission that religion is not immutable. Conscience is certainly not immutable. Belief is certainly not immutable. I would submit that culture too is not immutable. And language. But let's deal with the obvious ones like conscience and belief. Those are certainly not immutable grounds. And there's no authority of which we're aware that says all of the grounds in Part B must encapsulate immutability. Can I also make this submission, my lady? The journalists who are targeted by the respondents in this case have been targeted because of their belief, have been targeted because of their conscience. These are journalists who publish opinion pieces, who do investigative journalism, who write about their opinions. So if one wants to look at the class of journalists that is being targeted by the respondents in this matter, there's an argument to be made that they fall under Part A of the definition, that they are being targeted, as the respondents say, precisely because of what they say. But we submit that doesn't detract from our argument on Part B of the definition, that occupation is a ground that satisfies all the requirements of Part B of the definition. And if your ladyship is with us on Part B, that occupation ought to be regarded as a prohibited ground, then journalists, then attacking someone because of the work they do as a journalist, besides the fact that you're attacking them because of what they say as journalists, certainly would qualify under Part B of the definition. So the particular journalists who are being attacked in this matter, in our submission, fall under both Part A, because they're being attacked on the basis of their conscience and belief, and Part B, because they're being attacked by virtue of the work they do as journalists. What they have done is that they have enabled or created an environment in which the abuse, intimidation, and harassment of journalists is encouraged. And then this, we say, undermines their dignity. We deal with that in 26. And it has had the effect, your ladyship will recall, under the definition of harassment, I read to you that the unwanted conduct must be calculated to induce submission by actual or threatened adverse consequences. And many of, well, not many, but some of the journalists have toned down their reporting because of this fear that they may be subject to attacks by the respondents or their supporters if they report critically on the EFF. But, my lady, the very job, the very profession that the complainants follow puts them in a space where they because they are political reporters, because they are investigative reporters, they are going to investigate and talk about and opine about politicians. So it puts them in a space where they are going to be writing about these politicians. And if they are writing honestly, or what they believe, in their belief, is honest opinion, the probability of them clashing with the politicians is particularly high. It happens all the time that reporters who write politically and who opine politically write critically about the politicians that they investigate. And so when it happens that they write critically about the EFF or Mr. Malema, then they become susceptible to attack by the politicians themselves and their followers. And we say that vulnerability is comparable to discrimination on a ground in Part A of the definition. Because it's by the very nature of the work that they do that they are going to come into conflict with politicians. And it is by the very nature of the work that they do that they render themselves or expose themselves to being vulnerable to these attacks. Now, to answer your ladyship's question about Section 10 not protecting journalists, we say that everything in our constitutional dispensation is directed, well, not everything, but there are particular aspects of our constitutional dispensation that are directed in favor of the protection of journalists. We say that because, first, we start with Section 16 of the Constitution. And as I said earlier this morning, Section 16 specifically protects, besides freedom of speech and expression, it specifically protects freedom of the press and other media. We say it does that because it recognizes the vulnerability of journalists and the vital role that they play in sustaining our democracy. In fact, my lady, journalists or the media is the only profession that is expressly protected by our Constitution. We make the point in 29 that hurt or harm in the context of the Equality Act is not limited to direct physical harm, and it extends to an attack on dignity. I'm not going to read everything, my lady, but there is a reference there to the Supreme Court of Appeal decision in Wachanuka, in paragraph 29.1 of our heads. In paragraph 30, I deal with the definition of harassment, which I have already dealt with. And in 31, my lady, that this has been unwanted conduct which is persistent, that the individual complainants say as much, so subjectively they say that is so, objectively we submit that must be the case. And in 32, my lady, we make the point that because of this hostile and intimidating environment, journalists have already started to have fears or reservations about reporting on the respondents. We refer to what Ms. Munsami says in 32.1. She says that she's finding it increasingly difficult to do her work. Ms. Van Wyk says the same. She says that the aim of the comments or tweets were to shut me down and to stop me and journalists like me from writing articles that are critical of the EFF and its leaders. Mr. Basson is concerned, particularly about the effect on young journalists. Mr. Basson says this is likely to have a chilling effect on a younger generation of journalists. Now, my lady, no doubt the respondents will argue, well, this is what they say, how can we believe them? These are their fears, but if they just wrote as responsible journalists, they wouldn't suffer any of this harm. Yes, this is what they say. But objectively speaking, this must be the case. If one is a journalist who is a political reporter, an investigative reporter, who writes critically about politicians, if the politicians about whom you write are not going to accept that you have a right to write critically about them, but instead are going to attack you and to incite their supporters to attack you and stand by whilst their supporters are attacking you, then you would be crazy to continue doing that, because ultimately it's going to end very badly for the journalists concerned. It can't be simply that Mr. Malema can say, all of this will stop when you start acting professionally. What that means is that Mr. Malema has taken it upon himself to decide, or the EFF have taken it upon themselves to decide, when the harassment, abuse, intimidation of journalists will stop. And they say that will stop when you start writing things that don't make us upset, don't anger us, don't cause us to say these things about crushing the enemy. My lady, that can't be right. Now, the respondents say that the claimants haven't relied specifically on sections 10 and 11 of the Equality Act. The affidavits we submit are clear, my lady, that the statements constitute hate speech. Ms. Mahlasi says a number of times in her affidavit, which the others have all signed onto, that this constitutes harassment of journalists. The very relief, my lady, which is sought is relief which stops the harassment and the hate speech and the attacks on the journalists. The Equality Act deals with three issues, and three issues only: unfair discrimination, hate speech, and harassment. I thought there was a problem. The relief that is sought specifically speaks about hate speech and harassment. It's a legal question whether or not what is described in the affidavits constitutes hate speech, whether or not what is described in the affidavits constitutes harassment. If it does, and your ladyship finds that journalists are entitled to seek relief under the Equality Act, then certainly the complainants will be entitled to the relief sought. There is a paragraph in Mr. Malema's affidavit which says that the complainants have abandoned reliance on Section 11 of the Equality Act. Ms. Mahlasi explains that in the replying affidavit, and the position is simply this. The complainants sought to add to the relief that is claimed in Annexure B The relief that they sought to add was, in addition to interdictory relief, which is what is claimed, they also sought declaratory relief. An order declaring that certain words and conduct constitutes both hate speech and is harassment. The attempt to introduce the declaratory relief was opposed by the respondents. And because that was going to cause the matter to be postponed even further, and in fact today was going to be used to argue whether or not we should be entitled to extend the relief, the claimants withdrew the affidavit seeking the additional relief. But what was withdrawn was an affidavit seeking both hate speech and seeking a declarator that the statements constitute both hate speech and harassment. There's no basis for suggesting that the complainants waived any reliance on Section 11 of the Equality Act. Now, my lady, the position of the respondents is slightly curious on the issue of the protection of journalists, because they say that they accept that the Constitution protects freedom of expression, they accept Section 16 of the Constitution. They say that journalists should be free to work in an environment free of harassment. This is in paragraph 39 of our heads, and the reference to Mr. Malemas' answering affidavit is there. But Mr. Malemas says it is part and parcel of certain jobs that no matter how professionally one conducts oneself, one is still at risk of abuse. So the respondents are saying, yes, the Constitution protects freedom of expression, but journalists are not entitled to relief qua journalists under the Equality Act. Milady, in our heads of argument, we've highlighted various judgments of our courts regarding the importance of the media. I'm not going to read that out. We refer to the Van Breda judgment, the 2017 decision of the Supreme Court of Appeal. There's Kumala versus Holomisa, again the Supreme Court of Appeal. There's National Media Limited versus Bukhoshi, 1998 Supreme Court of Appeal, and it's all about the importance of a free and robust press to our democracy. And the same position was articulated by this court in 1995 in Government of the RSA versus Sunday Times newspaper, and that's at paragraph 40.4 of our heads. But, milady, the important point is this. How can you guarantee the protection of the press and other media without guaranteeing the protection of journalists? The Constitution says there shall be freedom of the press and other media. The cases say we must protect our press because because the media play such a vital role in our democracy. The simple point, milady, is that the media constitutes or is made up of by the people who work in the media. The people who work in the media constitute the media. Yes, there are production houses and corporations, but the people, the individuals who report, who articulate their opinions and their views, those people, those are the individuals who are the journalists. And if you don't protect the journalists, if you can't protect the journalists, then to talk about protecting the media and other press with respect is meaningless. If one is going to protect the media and other press, then one has to protect the journalists. and we have to protect the journalists from hate speech, and we have to protect the journalists from harassment, because if we don't, it's going to be open season on journalists that is hurtful, harmful, incites harm, promotes hatred, or is calculated to induce submission. A compliant press is the last thing we need in this country.
But the freedom of expression in the media, Mr. Berger, is not unrestrained. Is that correct?
That is absolutely.
The Constitution allows for its limitation in certain instances.
Yes.
You agree with me?
Yes, I do. And my lady, that leads me into another point that I can deal with right now. The Constitution and the Constitutional Court and other courts have said quite clearly that the freedom of the press is not unrestrained. But the courts have said that our law of defamation is what restrains the media. So the media can't publish statements that are defamatory unless they can prove certain defenses, and what our law does is it places an onus on the press to justify the publication of defamatory statements. You can, as your ladyship knows, truth and public interest, protected comment, and most recently from Bohoshi, reasonable publication is also qualified privilege. But it's the law of defamation which puts an appropriate limit on freedom of the press and the media. So, my lady, quite rightly, if the respondents and Mr. Malema, EFF and Mr. Malema have a problem with any journalist, they can sue that journalist for defamation. They can report that journalist to the press ombudsman. Our learned friends say that that's ineffective. But that is the regulation that is put in place, certainly with the press ombudsman. But our law of defamation is not ineffective. An adverse costs order against a newspaper will hit hard. And in the days of now, our courts are getting more creative with costs orders. There's the possibility that there could be cost orders against individual journalists, if appropriate. So our law is capable of limiting journalists in what they write and what they say. But, my lady, that's a different debate with respect from protecting journalists from the consequences of hate speech and harassment. Because then what is happening is one isn't limiting what they say. One is seeking to shut them down. If a journalist is threatened with physical harm or psychological harm, or a journalist's family is threatened with harm, that has the capacity of shutting that journalist down for good. And that's not limitation. That's just a shutting down. We submit that by protecting freedom of the press and freedom of expression, one allows journalists to operate in that protected space. But it's not an unlimited space. Once they behave in a certain way that is beyond the space, their particular speech will attract negative consequences, and negative consequences from the courts or other regulators. So, my lady, we submit that your ladyship has jurisdiction to entertain this complaint, and that the complainants are entitled to relief in terms of Section 21, subsection 2 of the Equality Act. As I said, the relief that they seek is set out in Annexure B, and Section 21(2) of the Equality Act says, after holding an inquiry, the court may make an appropriate order in the circumstances, which means we submit that your ladyship is entitled to make any appropriate order in the circumstances, including if an order restraining unfair discriminatory practices or directing that specific steps be taken to stop the unfair discrimination, hate speech, or harassment. So your ladyship can restrain that, which is an interdict. H, an order for the implementation of special measures to address the unfair discrimination, hate speech, or harassment in question. J, an order that an unconditional apology be made, which your ladyship will see is part of the relief sought. And L, an appropriate order of a deterrent nature, including the recommendation to the appropriate authority to suspend or revoke the license of a person. Well, we emphasize the words an appropriate order of a deterrent nature. And then finally O, which is an appropriate order of costs against any party to the proceedings. My lady, if your ladyship is against us in finding that there is no jurisdiction, that your ladyship has no jurisdiction to entertain this complaint because journalists are not protected under the Act, then we submit, my lady, that the appropriate relief would then be to refer this matter or transfer this matter to the High Court. The reason we say that is, if your ladyship looks at Section 20 sub 3 of the Act, sub 3 says, the clerk of the Equality Court must, within the prescribed period of receiving such notification, refer the matter to a presiding officer of the Equality Court in question, who must, within the prescribed period, decide whether the matter is to be heard in the Equality Court or whether it should be referred to another appropriate institution, body, court, tribunal, or other forum, the alternative forum, which, in the presiding officer's opinion, can deal more appropriately with the matter in terms of that alternative forum's powers and functions. Now, your ladyship wasn't the judge that was initially seized with this matter. In fact, your ladyship is the third judge seized with this matter.
Third? That was the second.
No, my lady, third. I don't want to.
Okay.
Yes, but the first judge seized with the matter never made this determination that is under 20 sub 3 of the Act. Our submission is that what the Act is designed to do is it's designed to give relief pursuant to Section 9 of the Constitution in circumstances where that relief, where it is capable of giving such relief. But if a person comes to the court and that person puts forward a complaint which the court holds is not within its jurisdiction, the appropriate course of conduct is not to simply dismiss the complaint. The appropriate course of conduct is to find which forum is more appropriate to consider that complaint. And we submit that because your ladyship sits on other days in the same court as a judge of the High Court, that your ladyship can swap hats and refer the matter to your ladyship sitting as a judge in the High Court. In paragraph 44.1 of our of our heads of argument. We cite the case of Minister of Environment Affairs and Tourism versus George, 2007 3SA, a judgment of the Supreme Court of Appeal, dealing with the issue of concurrent jurisdictions. And the court held, given that the problem of concurrency will inevitably recur, the most productive and expeditious way of achieving efficiency would seem to lie in the matter being referred to the same High Court judge who, in his capacity as an Equality Court judge, is presiding in that court. So it may be that there's a claim where certain aspects of that claim falls under the jurisdiction of the Equality Court, and other aspects of the claim falls under the jurisdiction of the High Court. The Supreme Court of Appeal says the judge sitting in the Equality Court must wear two hats and deal with the Equality Court matter wearing the Equality Court hat, deal with the High Court matter wearing the High Court hat. The Constitutional Court referred to George in the matter of De Lange versus Methodist Church, 2016 decision of the Constitutional Court. And at paragraph 58, the Constitutional Court said, in George, it was held that Equality Court proceedings and constitutional challenge proceedings may be consolidated for hearing before a single judge sitting as Equality Court and as High Court. There is indeed much to be said for this approach of permitting consolidation of disparate claims before a High Court. The consolidation will not only serve the procedural requirements of the Unfair Discrimination Act, which is the Equality Act, but will also avoid piecemeal litigation and costs. So, my lady, our submission is that our courts, both the Supreme Court of Appeal and the Constitutional Court, have quite clearly said there is no problem with a High Court judge wearing two hats. Bearing in mind that the machinery of the Equality Act is such that when a complaint comes in, if it's not a complaint that should be properly be before the Equality Court, then that complaint can be referred to an appropriate forum, including the High Court. If that is the machinery of the Act, we submit that there would be no difficulty standing in your ladyship's way of, if there's a finding against us on jurisdiction, simply transferring the matter to the High Court and considering the matter as a High Court judge would consider the matter. In which case it would then be argued on general principles of interdicting harm. So, my lady, I'm not suggesting that this court doesn't have jurisdiction, but I'm making the submission that when your ladyship writes the judgment, it might be that we have to come back for a second round of argument in the High Court. My lady, if your ladyship finds that this court does have jurisdiction, then and only then would it be appropriate to move on to the question of the strikeout. We have in your ladyship's bundle of cases a judgment of the High Court in the matter of Brown versus the Economic Freedom Fighters and Mr. Malemas. And that had to do with a case where Ms.